Let's talk a little bit more about the marketable product rule, because as we'll see, this has proven a fertile area for litigation. So let's talk a little bit more about how you draft a lease to say you want a marketable product rule and vice versa. So as a reminder, the marketable product rule, the idea is, hey, the lease says that you have to produce and that you have to share that production with the lessor, the landowner. And so to have a product, it has to be something you can sell. It has to be of marketable quality. And that may mean bringing it someplace it's sold, in other words, transport, as well as processing it, removing impurities, etc. Also, the idea is, hey, to keep a lease, you have to have production and paying quantities. If it's not yet something that somebody will buy, it's not yet marketable, then you don't have production and paying quantities. So production should include everything, including processing, transport, to get that product in shape where it can be sold. As we've described, some of the problems with a marketable product rule is that it doesn't seem to match the literal terms of leases that say you get the value of the gas at the well. And it can be bad policy because it gives the oil and gas company the incentive to sell the gas earlier, even without doing some things that could make it more valuable, transporting it to markets where it's needed, processing it, etc., because the oil and gas company doesn't get the lessor to share in those costs with the marketable product rule, has to pay for them all itself, so it may be less likely to take those economically rational steps to improve the value of the gas. It also, of course, can be a little bit of a slippery target as to what is marketable. Maybe the gas at the well can't be sold initially because there's not a market available, nobody wants the sour gas, etc. But that market may develop next month. Does that mean that all of a sudden you can sell it at the well? And we see different potential results on that. Also, there's this theoretical problem, which is, isn't it always marketable? I mean, in theory, somebody would be willing to purchase that gas if we lower the price enough, or maybe nowadays paid enough money for somebody to take it away. So it's still a product wherever it is, right? The only reason we move it downstream and process it, transport it, is to get more money for it. But it was still a product at the wellhead. So those are some of the concerns people have expressed. Now, let's look at a jurisdiction where they apply the marketable product rule. And what we'll see is that the marketable product rule, although it's often talked about as something that is implied in fact by the contract, that the lease, if they thought of it, this is what the parties would have said: I want 1/8 of the value of all the gas by the time you get it ready to sell, so that it's an implied in fact covenant. You'll see that some courts make it very difficult to contract out of that. So if you have the marketable product rule, you might have to write the lease very specifically in those jurisdictions to be clear, no, the oil and gas company should be allowed to make deductions for things it does to make the gas more valuable. So here's an example. In this lease, in the Tawney case, which is on page 388 of your book, it said, the lease said you get 1/8 of the price, net all costs beyond the wellhead, or less all taxes, assessments, and adjustments. So that sounds like a netback method. You get the wellhead price, right? So you get whatever we got for it eventually, minus all the costs to get it there from the wellhead. But court says, no, that's ambiguous. And the lessor cannot deduct any of the costs between the wellhead and the point of sale. Okay, so why did the court say that? Well, it seems that the court was worried that, really we should go with that marketable product rule, and if you don't want that, you're gonna have to be really clear. You might have thought this lease was clear, well, you're gonna have to be even clearer than that. So what the West Virginia court said is, to be effective, if you want to take deductions for things that you do after the well, you want to use that netback method, you have to expressly provide that the lessor shall bear some of the costs incurred between the wellhead and the point of sale. So you have to kind of include that magic language. But just so we're clear, when I say net all costs beyond the wellhead, I'm saying the lessor pays for its share of pipeline transport, processing, etc., beyond the wellhead. Second, you have to identify with particularity what specific deductions the lessee intends to take. So if you want to take a deduction for the cost of gathering or transport, if you want to take a deduction for the cost of compression or processing, you have to say so. And then third, the lessee, the oil and gas company, needs to indicate the method of calculating that amount that's going to be deducted for post-production costs. So he needs to say, look, in the lease, they have to say, I am going to show you the bill from the pipeline company per MCF of gas that I've transported to make that deduction. So in other words, the courts, they're in theory saying, well, look, we think you probably meant generally you wanted the marketable product rule. But if you didn't want the marketable product rule, you wrote something like this that kind of suggests you want the netback method, you're going to have to be really clear about it. Otherwise, the courts are not going to uphold your language. All right. Now let's look at the flip side scenario. In Texas, we generally say production means at the wellhead, and so we use the netback method. However, let's say you want the marketable product rule. You want no deductions. You want an eighth share of that final price. How would you write that up? Well, what we'll see is it can sometimes be difficult because the courts in Texas will focus on your literal words, and so you better be clear about what you want. So if we look at Heritage Resources as a famous case, 1996, Texas, page 393 in your book. Here's what the lease said. The gas royalty shall be the market value at the well, okay, normal Texas language, but there shall be no deductions from the value of lessor's royalty by reason of any required processing, cost of dehydration, compression, transportation, or any other matter to market such gas. Okay. So notice, seems to be a little bit of a contradiction, because if you say market value at the well, that suggests the netback method. So you get 1/8 of everything that's produced at the wellhead. To figure out how much it's worth at the wellhead, you take the final price, which you got eventually at market, and you strip out those costs. But then it says there should be no deduction from the value of the lessor's royalty. So how do you reconcile those two statements? Well, here's what the Texas Supreme Court said. It says, look, at the well means you get to subtract everything after the wellhead. That's the netback method. We're used to that in Texas. It says the remainder is surplus. So all this doesn't accomplish anything. Well, why is that? Well, the Texas Supreme Court says, yeah, there shall be no deductions. There are no deductions. The netback method isn't deductions from your royalty. It's just trying to determine what your royalty is, okay? So your royalty is a share of the production at the wellhead. We need to know what the price is at the wellhead. When we subtract out those costs, that gives us the price at the wellhead. We're not deducting from your royalty. So the rest, yeah, there shall be no deductions. We're not making deductions. We're just subtracting to find the value at the well. You can decide for yourself whether you consider that convincing. So the lease says gas royalty shall be market value at the well, but there shall be no deductions. Court says that the rest is surplus. Okay, so what is the court saying here? Court is basically saying, look, when you said at the well, that means we have to have a wellhead price. If the gas wasn't sold at the well, couldn't be sold at the well, we're not sure. It wasn't eventually sold there, and it was sold downstream. we still need to figure out what's the value at the wellhead. And so to get that, we take our $3 price, we subtract $1. So we take $3, we subtract $1 to gather, transport, and process, and we get that $2 value at the wellhead. Now, as the lessor, you say, wait a second, I said no deductions. Texas Supreme Court said, these aren't deductions. We are giving you your full $2 at the wellhead price, which is what you put in your lease. We just had to subtract this out. We didn't deduct it, we subtracted it. Again, you can think about whether you consider that convincing. Okay, so to see how far the courts can go in interpreting this language and the problems it can create if you're not clear about what you want, let's look at this Hyder versus Chesapeake case. This is only described, you have this text in your book. I'm going to describe it in a little bit more detail so we can think about it as a hypothetical, but we don't have the full case in the book. So in this case, the lease said that the lessor would receive a perpetual cost-free, except only in its portion of production taxes, overriding royalty of 5% of gross production. And the parties agree that heritage resources shall not apply to this lease. Okay. So if you find yourself drafting a lease and you think that you want to put in there that a Supreme Court of Texas case doesn't apply to a Texas lease, I would strongly urge you, think again. That is not how things work. Heritage resources isn't a substantive rule, right? Heritage resources is this case that we just talked about, about saying at the wellhead doesn't require deductions. We just have to subtract back to get that net back value. So it was just interpretation of what those words mean. You can't say it doesn't apply to this lease. That's like saying logic does not apply to this lease. That would not help the courts interpret it. So what were the parties trying to do here? Well, my personal opinion is that they were trying to say this royalty should be paid on the product when it's finally completed as a marketable product, no matter where it's sold. So no net back allowed, no deductions allowed, no subtractions allowed. I think that's what they were trying to say. By the way, if you want to say that, all you have to say is, if the royalty is 5%, you say, I want 5% of the gas proceeds no matter where sold, right? So not the wellhead price. The wellhead price is what gets you in trouble. We're saying simply production, because production in Texas means at the wellhead, and that's what got them in trouble here. So the argument of the oil and gas company that thought it should be able to still do the netback method says, oh, okay, what does cost-free mean here? Cost-free just means, as with a normal royalty, no production costs. As an oil and gas company, we can't charge the lessor for drilling the well, for fracking the well, etc. It's cost-free in that sense, like any royalty. Chesapeake says production in Texas, this is true, means at the well. So when is the gas produced? When it hits the wellhead. There are other states, we talked about Kansas, Colorado, where production is complete when the product is marketable. But in Texas, it's produced at the wellhead, and so therefore we should give them the value at the wellhead. Chesapeake also notes that under this lease, it was specific that if the Hyders had the option of getting their gas in kind, so rather than getting money for it, just receiving 5% of the gas, and they would have had to pay the cost to do everything with it, transport it, process it, etc. afterwards. So they say, look, let's go with the heritage resources rule. Who knows what cost-free means? Who knows what they mean by heritage resources won't apply? But this is just a regular Texas at the wellhead production royalty. We get to use the netback method. The hiders say, whoa, 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 whoa. So a royalty is obviously free of production costs. Everybody knows with a royalty, the oil and gas company doesn't get to charge the cost for drilling the well that it has to drill. So cost-free here must mean something else, and what it means is no post-production costs. Okay? We don't have to pay any of those costs for production. And they also say, look at what this Heritage Resources disclaimer said. They were obviously wanted the marketable product rule. They didn't want any netback allowed, and they were frustrated that netback was allowed in Heritage Resources, even though they said no deductions. And so they were really explicit. Heritage Resources shall not apply to this lease. That's obviously what they meant. All right. Well, how does this badly divides the Texas Supreme Court? Here's what the majority says. First of all, everyone on the court agrees. You can't just say a Supreme Court of Texas rule doesn't apply. We're in Texas, we're applying Texas law, so heritage disclaimer is irrelevant. You can't disclaim Texas, you can't disclaim Texas law. And besides, heritage was not it was a statement about what the logic meant of calling something a royalty at the wellhead. It wasn't a substantive rule, so you can't disclaim that. Secondly, the majority says, okay, it's possible that cost-free is just redundant, saying, look, this is a royalty, of course, that's what it's for. But here, majority says, we think it was a no production cost, basically like a marketable product royalty, right? So that's what we think they were trying to do. So cost-free here means that you get 5% of the final cost of the processed and transported product, not just the netback. Okay, the lease says, it also notes the lease says cost-free except Chesapeake can deduct production taxes. Okay, those are post-production. Production taxes are actually, under Texas law, post-production costs. So what they're saying is, when they say cost-free other than production taxes, they're carving out one kind of post-production cost and saying you can go ahead and charge that. That implies the other ones you can't charge. And so we're left with a successful attempt to follow the marketable product rule, say no netback, you get 5% of the final product. Finally, they say, look, yes, the hiders would have gotten less if they'd taken the gas in kind, but that doesn't mean they don't get more if they don't take the gas in kind, if they just want the money. Right? What does the dissent say? It's pretty interesting. The dissent says, look, it's 5% of gross production. Production in Texas means production at the wellhead. So as soon as it comes out of the ground, it's produced, you get 5% of that. If money is spent after that to make the gas worth more, that can be net back to figure out what 5% of production at the well was worth. The dissent says cost-free. Okay, yeah, it's redundant. Often people say, I want a cost-free royalty. Of course, a royalty is cost-free, but you don't need to identify that. So cost-free just means for the normal thing that we think of with royalties, which is you don't have to pay for drilling the well, et cetera. All those costs up to the oil and gas coming out of the ground. Okay, this is kind of interesting. Need for production taxes exception makes sense because the Chesapeake's going to have to charge for production taxes. But you might think, well, production taxes, that sounds like a production cost. And so production costs, right, just like drilling the well, everything up to oil and gas coming out of the well has to be paid by the oil and gas company. And so that's why they said, except for production taxes. Now, they say the majority's argument is that, well, production taxes are a post-production cost. And so they were trying to say that all the other post-production costs were not to be charged. But the dissent says, wait a second, that doesn't even make sense. you're suggesting that they are following our precedents very carefully, and yet in the same lease, they said they didn't even want to follow heritage resources. So the dissent uses some sarcasm. It says, we don't think this was written out of studied fidelity to our precedents. Finally, the court says, it's not hard to get the marketable product rule if you want to in Texas. You don't have to go through this rigmarole of saying, don't charge this, don't subtract for this, don't subtract for this, and don't apply heritage resources. All you have to say is, I want 5% of what the company actually received upon sale. You'd say no matter where sold, whatever. The point is, when the gas was exchanged for money, I want my percentage of that amount. I don't want a net back. So you don't need to go through this rigmarole. And I think something that you see in oil and gas in general and leases in particular is that often lawyers get themselves into trouble by just trying to glom on new language to an existing lease to solve some problem from the case law when they could go back to simpler language. We saw that in some respects with the continuous operations clauses, et cetera, so that the lease language can get very confusing, and that's what seems to happen in both Chesapeake versus Hyder and Heritage Resources.